Facts of the case. JJ Limited is a company that produces videos and tapes of lectures and accompanying notes for the purpose of teaching law to overseas students by distance learning, with 10 staff working for them on a full-time basis, including Susan. Susan is a senior staff and an author of a leading textbook on Asian law. She is employed on a 5-year contract to develop new materials within her field. Her contract strictly requires her to not work with any other firm of law tutors during the period of her contract and for another year after the contract ends. However, Susan has breached her contract in her 3rd year working for JJ Limited by sending in her resignation letter and later accepted an offer of employment from Law Studio, a tutorial firm based in Singapore. The problem then arises when all the materials that Susan has been working on has disappeared from the office. This worries JJ Limited if in any case the materials are now in the possession of Law Studio. Therefore, the rival company is now in advantage to gain clients with those materials. Moreover, the company believes that Susan had taken a list of clients with her when the company found out that its current students have received advertisement from Law Studio on the materials. JJ Limited is worried that their potential clients are taken away from them as well as one of their assets, Susan, who intends to work for a rival company, which is Law Studio, which now it makes them a competitor. Being a small company with only 10 full-time workers, which now down to only 9 after Susan left, their position is threatened when it involves paying clients and valuable staff opting for another business. JJ Limited is now looking for a way to ensure that Susan does not abuse her rights in labour by considering JJ Limited's part in the employment contract which she has to oblige. The issues are discussed based on the breach of negative contract in regards to her employment contract and breach of confidence on the materials and the list of clients which are deemed as private property under trade secrets if he manages to prove so. Issues. There are 2 issues that are being discussed in this assignment. The first issue is on the negative agreement and the second issue is discussed on the breach of confidence. The first issue on negative agreement is whether JJ Limited can plead injunction to enforce a negative agreement for Susan to not work with another company, while the second issue on breach of confidence is whether there is a breach of confidence by Susan on the materials and the list of clients that were alleged to be taken away when she left JJ Limited.
Hello, my name is Nursyyaani. I'm here to present for the first issue regarding breach of negative agreement that has been found in the question. In common law, the enforcement of a personal service entertainment contract by methods for a negative injunction can be referred through the case of Lumley and Weiner in 1852, where the defendant, Johanna Weiner, who is an opera singer, was engaged by the claimant to perform in his theatre for a period of 3 months. The injunction was granted despite it having the effect of forcing the defendant to sing for the claimant. This means the court cannot restrain Weiner to sing for Lumley, but the court establishes that it might enjoin Weiner from singing for another person, particularly Covent Garden, who is an opponent theatre. The English decision does not require as the basis for the issuance of an injunction the presence of any element apparently, except for the negative covenant. The question of whether or not the defendant is a person of unique ability is nowhere to be discussed. It is undoubtedly true that in most cases, the defendant has been enjoined was a person standing high in his profession, but this fact does not seem to have influenced the court in giving relief, and occasionally relief has been given where that did not appear to be the situation, based on the case of Crimston and Cunningham. In 1894, it is important for the employer to not show any competitive harm even though the defendant was only an understudy. Occasionally, it has been said that enjoining a defendant employee from working for anyone except the plaintiff is unjust and against public policy, and this is in effect placing him in a state of involuntary servitude, contrary to the 13th Amendment of the Federal Constitution, because the almost invariable result of the injunction is to compel the defendant to work for the plaintiff. However, injunction can be applied in cases relating to breach of negative undertaking in contracts of employment. This will be sought by the employer in order to prevent the employee from leaving the employment and the other way around. We can refer to the case of Evening Standard and Henderson, where an interlocutory injunction could properly be granted to restrain an employee from working for one of his employer's rival in breach of his contract.
Hello, I am Nisa. I'm going to explain the position of the breach of negative agreement in Malaysia. There are two provisions to be referred under the Specific Relief Act 1950. Firstly, Section 54 that deals with several circumstances where an injunction cannot be granted, and secondly, Section 20 subsection 1 that deals with types of contracts which are not specifically enforceable. In Malaysia, the grant of injunction in matters involving the breach of negative undertaking was further strengthened by Section 55 of the Act. The court in the case of Pertama Cabaret nightclubs in Bertujuan and Rahman emphasized the existence of Section 55 as to have wider scope compared to English law, where the issuance of injunction covers both an express and implied negative stipulation in a contract. This can be further seen in the case of Datuk Abdullah bin Ahmad and Syarikat Permodalan Kebangsaan, where the plaintiff was removed as a chairman of a company and he obtained an injunction to prevent such removal against the defendant's company. The defendant consequently appealed. The court allowed the defendant's application in part. It was highlighted in this case that contracts for personal services cannot be specifically enforced under Section 20 subsection 1b of the Act. Consequently, Section 54 provides that an injunction cannot be granted to prevent a breach of contract, the performance of which would not be specifically enforced. The learned judge of this case further highlighted the difference with English law, where under the English law, an injunction can be granted only when there is an express negative condition or stipulation, while Section 55 covers both implied and express negative stipulation. In the present situation, Susan's contract requires her not to work for any other firm during the period of her contract and for 1 year thereafter. But in the period of the term, she left JJ Limited and worked for another tutorial firm named Sudoku. Here, Susan breached two conditions in performance of employment contract for a term of 5 years and 1 year thereafter. When she submits the resignation letter, she was on her second year of her employment contract and thus resigning earlier makes her performance of 5 years term incomplete. Secondly, there is a term in her previous employment to not work for any other firm for another year thereafter. When she accepted the employment in tutorial firm, namely Sudoku, despite a year having not passed after the resignation, this is considered as a breach of negative agreement. Generally, injunctions will not be granted to enforce contracts for personal services based on the case of Chapel and Times Newspaper Limited, where the court in this case will not restrain an employer from terminating a contract of employment. However, an injunction can be granted to enforce a negative agreement based on Section 55 of Specific Relief Act 1950. The negative agreement in question is the clause where Susan cannot work for another tutorial firm during the period of contract and 1 year thereafter. This clause is within the employment contract which she agreed to when she initially worked for JJ Limited. When she resigned, the clause is still in effect for the latter part of the clause of 1 year thereafter, as to mean that this binds upon her to not work with another firm for a year after her employment ends. The fact that she accepted employment at Sudoku goes to say that she breached the aforementioned negative agreement. The cases that we can refer to are Lumley and Wagner, where injunction should be granted to restrain the breach of a negative stipulation and it was not possible to obtain specific performance. Other than that, the case of Pertama Cabaret nightclubs in Bertujuan and Rahman refers to the wide scope of Section 55 regarding the issuance of an injunction covers both an express and implied negative stipulation in a contract.
Hence, we advise JJ Limited to proceed with the plea of injunction to enforce the negative agreement. Susan should be made to continue working under JJ Limited until the term agreed in the contract has been fulfilled. The remaining 1 year after resignation is not enforceable due to Section 28 of the Contract Act 1950 under the non-conflicting clauses for employment agreement. Thank you.
I'm Aisyah and I'm going to explain on the remedy for the first issue. So for the first issue, JJ Limited can apply for an interlocutory injunction. Interlocutory injunction is a provisional measure taken at an earlier stage in the proceedings. It was provided in Section 51, Subsection 1 of the Specific Relief Act that it is a temporary injunction such as to continue until a specified time or until the further order of the court. In the case of American Cyanamide and Ethicon Limited, the judge laid down 3 elements that must be fulfilled by the plaintiff before an interlocutory injunction can be granted. Firstly, the plaintiff's case is not frivolous and vexatious. Secondly, damages would not be an adequate remedy for the loss of the plaintiff. And thirdly is the balance of convenience, in which the court will have to see the balance of the risk doing injustice towards each party. In Malaysia, the Malaysian courts have accepted the elements as laid down in American Cyanide's case. In the case of Siva Perumat and Hia Seok Yong Realty Sdn Berhad, the judge stated that the plaintiff must show that there was at least a serious question to be tried, provide factual facts to convince the court that he had a real chance of succeeding at trial, and any other discretionary considerations which may arise. In this case, JJ Limited clearly has a real prospect of succeeding at trial as they have signed a contract with Susan, but she is yet to fulfill her obligation in the contract. JJ Limited has a valid cause of action as they are the party that will be directly affected by Susan's action. This shows that JJ Limited has a serious question to be tried and his case is not frivolous and vexatious. Furthermore, if JJ Limited were to succeed at trial, it can be seen that damages would not be an adequate remedy because there will be an unclear number in the total of loss that will be suffered by JJ Limited. JJ Limited will lose a skilled employer, which is the asset of the company, and they will suffer irreparable damage as the confidential material is now in the possession of another company. Lastly, for the balance of convenience, it is clear that JJ Limited will suffer more than Susan if interlocutory injunction is not granted. This is because JJ Limited will lose a skilled employer, which will substantially affect their company, while Susan will still get paid if she continues to work with JJ Limited. Therefore, interlocutory injunction may be granted to JJ Limited as they have fulfilled the 3 elements.
Hi, my name is Nasrin, and the second issue is whether there is a breach of confidence by Susan on the materials and the list of clients that were alleged to be taken away when she left JJ Limited. Breach of confidence is an equitable doctrine which protects the rights of confidentiality and allows a person to claim remedy when their confidence has been breached. In the case of Coco and A. Clark Engineers Limited, a claim was made for breach of confidence in respect of technical information whose value was commercial. Judge Magary held that there were 3 elements in establishing breach of confidence, which are: firstly, the information must be confidential; secondly, the information must be communicated in circumstances importing an obligation of confidence; and finally, there must be an unauthorized use of information. The first element of breach of confidence: information is confidential when it is not the common knowledge of the public. As per Lord Green in the case of Saltman Engineering Co. Limited and Campbell Engineering Co. Limited, something which is public property and public knowledge cannot per se provide any foundation for proceedings for breach of confidence. In the case of Electrocard Australia and 2 others and Majati RCS and others, Judge Kamalanathan Ratnam stated that confidential information covers all information of a confidential character, including firstly, personal secret or information; secondly, trade or business secret; thirdly, public and government secret; and finally, literary and artistic secret information. For trade secrets, we can refer to the case of Schmidt Scientific Sdn Berhad and Ong Han Swan, where the name and addresses of customers and suppliers were classified as trade secrets. The court held that obligation of good faith or fidelity on a representative or employee does not exist only during employment, but there is additionally an inferred obligation that restricts the usage of confidential information even after employment ends. Next, the information must have been communicated in circumstances importing an obligation of confidence. There can be no binding obligation of confidence if that information is blurted out in public or is communicated in other circumstances which negate any duty of holding it confidential. Judge Magary in the case of Coco and A. Clark Engineers Limited opined that the circumstances are such that any reasonable man standing in the shoes of the recipient of the information would have realized that upon reasonable grounds the information was being given to him in confidence, then this should suffice to impose upon him the equitable obligation of confidence. Finally, there must be an unauthorized use of information to the detriment of the person communicating it. In the case of Saltman Engineering Co. Limited, the judge decided that if a defendant is proved to have used the confidential information directly or indirectly obtained from the plaintiff without the consent of the plaintiff, either express or implied, he will be guilty of an infringement of the plaintiff's right.
Assalamualaikum and hi everyone. My name is Nur Aisyah. I will explain the application of the law. On the first issue, about the new teaching material. The material is confidential information based on the rules that has been explained earlier. JJ Limited is a company that produces notes, videos and tapes for the purpose of teaching law to overseas students by distance learning. Thus, the material is a product from JJ Limited and any disclosure must be authorized by JJ Limited because any unauthorized disclosure might give disadvantages to JJ Limited such as plagiarism by other company. In addition to that, new material is something that needs skills and expertise to create, which lead to JJ Limited specifically hiring Susan, who is a leading author of Asian law book, to develop the material. In Douglas and Halo, application of skill and expertise to create will give a rise of confidence. Thus, Susan or any reasonable man in Susan's position would know that he has the obligation to keep the material secret until JJ Limited authorized the information to be disclosed. However, all the materials that Susan has been working on has disappeared from the office. Susan, who has accepted the offer from the Sudoku, was suspected to take the materials together with her to her new workplace. If Susan indeed took the materials, there is an actual disclosure of information from Susan, and the disclosure is not authorized by JJ Limited. Hence, Susan had breached her duty of confidence. As was mentioned by my friends earlier, according to the electoral card case, list of clients is a trade secret which amounts to confidential information. Although JJ Limited did not mention to Susan that the information is confidential, but as the nature of the information is confidential, and any reasonable man in her position would know that there is an obligation to keep information secret. Hence, Susan also has the same obligation to keep the list of clients from the knowledge of the public. However, current students of JJ Limited have received advertisement materials from Law Sudoku and made JJ Limited believe Susan has taken the list of clients. If the claim is true, Susan had unauthorizedly disclosed the information of trade secret to JJ Limited's competitors, and JJ Limited might lose their customers due to Susan's action. That Susan had breached her duty of confidence.
Assalamualaikum Doctor, my name is Al-Saifee. So, what are the appropriate remedies that could be given in breaches of confidence? So, firstly is a prohibitory injunction. It is an injunction that requires a party to refrain from doing a specific act. This is provided under Section 4C of the Specific Relief Act and is known as a preventive relief. For example, in cases, in breaches of confidence, an aggrieved party may plead for this type of injunction to stop a defaulting party from continuing to spread and transfer certain confidential information or other sensitive materials that may injure him. In the case of Venables and Media Limited, the claimants were two notorious murderers who were convicted at the age of 11. An injunction was granted prohibiting the media from publishing any information about them until they reach 18. When they have reached 18, the claimants further sought the same prohibitory injunction to prevent multiple death threats that they were receiving. So the court granted this application on the grounds that to protect confidential information, even if to place several restrictions on freedom of speech, and that prohibitory injunction is adequate. The second type of injunction is mandatory injunction, which is a direction given by the court to a person compelling him to perform something. This is prescribed under Section 53 of the Specific Relief Act, where it is given where the injury of the plaintiff cannot be sufficiently compensated with damages, or where the injury itself is so serious that the restoration of things to their former condition is the only way whereby justice can be restored. In the case of Yohata Industries and Coin Master, where the defendant had violated licensing provisions, the court granted a mandatory injunction compelling the defendant to return several confidential documents to the plaintiff in regards to a product that he invented to prevent irreparable damages because those documents could not be compensated with money.
Hi, my name is Syafiq. We already come to the conclusion to advise JJ Limited. As in current matters, for the first issue, the issue is whether JJ Limited can plead injunction to enforce a negative agreement for the Susan not to work with another company. As for our point of view, the equitable remedy available is an injunction to execute the negative agreement ordered by the judge. In respect to the violation of negative agreement, we would like to counsel JJ Limited to continue to execute the negative agreement with a plea of injunction. Whilst also Susan should be allowed to continue working under JJ Limited until the term agreed in the contract is accomplished. Due to Section 28 of Contract Acts 1950, under the non-compete clauses in the employment agreement, the remaining year after resignation is not enforceable. Secondly, moving to our second issue, whether there is a breach of confidence done by the Susan and affecting JJ Limited. In the current situation, all the elements are fulfilled from the act was done by Susan was an act of breach of confidence. Not only that, the crucial and important part was when Susan accepted the offer from Studio.co was suspected to take materials together with her to her new workplace. As in general, the materials can be considered as new materials, which is not yet disclosed to the students, competitors and publics. By losing the materials which belongs to the company might put JJ Limited in disadvantageous position compared to other competitors. Hence, JJ Limited might seek for mandatory injunction by virtue of Section 53 of Specific Relief Act, where a court directs a person to perform certain acts. In this scenario, the court might grant a mandatory injunction rather than a prohibitory injunction, since those materials belongs to the company and significance important towards JJ Limited, and granting damages not only suffice towards them. Without granting the mandatory injunction, Susan might continue sharing the materials with Studio.co and mistreat the confidential materials. I think that's all from our group. Thank